والآن إن شاء الله بننتقل إلى فيديو تعريفي أعده زملائنا في كلية الاتصال شاكرين بالتعاون مع كلية القانون لمدة 3 دقائق يتحدث باختصار جامعة الشارقة وعن كلية القانون.
بعد التقدم الكبير والإنجازات المتتالية في ظل الرعاية الكريمة والدعم الكبير من قبل صاحب السمو الشيخ الدكتور سلطان بن محمد القاسمي عضو المجلس الأعلى للاتحاد حاكم إمارة الشارقة ورئيس جامعة الشارقة حفظه الله، أصبحت جامعة الشارقة منارة للعلم ومقصدا للطلبة في محيطها الإقليمي والدولي، وتطمح إلى أن تصبح منارة على مستوى العالم وتخطو خطوات ثابتة نحو ذلك. وهنا ترتكز خطوات الجامعة وبالجهود والمتابعة الحثيثة والمباشرة من قبل سعادة الأستاذ الدكتور حميد نجول النعيمي مدير الجامعة على الاستمرار والسعي الدؤوب في إثبات جدارتها وتميزها، مما أكد تحقيق العديد من الإنجازات والنتائج الكبيرة التي أسهمت وبجدارة في تعزيز مكانة جامعة الشارقة. وفي ظل التطور البحثي والعلمي الذي ينسجم مع توجهات وتطلعات ورؤية كلية القانون، الكلية التي حققت إنجازات كثيرة على المستوى المحلي والدولي في السنوات الأخيرة، مما أدى إلى الإقبال الكبير والمتزايد لطلاب البكالوريوس، وأيضاً تعتبر الكلية الأولى خليجياً في طرح برامج دراسات عليا ماجستير ودكتوراه في تخصص القانون بنوعي العام والخاص، إضافة إلى معظم طلبة الدكتوراه والماجستير يعملون في سلكي القضاء والشرطة. وسعيها في أن تكون مركزاً للمعرفة القانونية من خلال نشر الوعي القانوني والثقافة القانونية وبيان الحقوق والالتزامات وتعزيز سيادة القانون من خلال تشجيع ودعم المجتمع في فهم حقوقه والتزاماته الدستورية والقانونية في كافة الظروف والمجالات. وهنا عندما يكون القانون هو الفيصل في تحديد الحقوق والالتزامات للجميع دولاً وأشخاصاً طبيعية واعتبارية ومؤسسات، إذ سعت لتقديم هذا الملتقى بأبهى صورة علمية تحت عنوان الجوانب القانونية الموضوعية والإجرائية لجائحة كورونا.
Reporting delays became a source of concern since it left the World Health Organization unable to adequately and fully appreciate the extent of the threat and then to coordinate a necessary international response caused by a novel coronavirus strain, SARS-CoV-2. Important to note is that this was not the first time an international organization addressed the issue of a pandemic. While there have been few pandemics historically, but notably already in 1851, there was an attempt primarily by European states to meet in Paris in order to harmonize the regulatory response to the then harmful diseases of cholera and the plague. The effort was unsuccessful for a number of reasons, not unsuitable for a fuller discussion here. It must be said at the outset that a pandemic is an existential threat to humanity. In 1902, the Pan American Health Organization was created to deal with such issues, followed by the Office International de Hygiene Publique in 1907. Both of these organizations were precursors to the emergence of the World Health Organization, created as a specialized agency to deal with all issues of international health, with its constitution promulgated in 1946 and entering into force the following year. Keep in mind that it was the World Health Organization as the preeminent international organization that issued the international health regulations in 2005. That pronounced the rules for dealing with pandemics. Notably and unfortunately, those rules have not been complied with universally, resulting in immense numbers of fatalities. The World Health Organization assumed the role of the collective agency to face the pandemic challenge through cooperative efforts. Health officials have determined that the virus was transmitted through fourth generations. The original infected person contracted the virus from a non-human. It is estimated that the virus has an incubation period of 2 to 14 days, with the potential asymptomatic transmission. There have been 5 declared public health emergency of international concerns. The influenza virus, H1N1 in 2009, polio in 2014, Ebola in West Africa in 2014, and Ebola in the Democratic Republic of Congo in 2019. Subsequently, the World Health Organization declared on March 11, 2020, COVID-19 a public health emergency international concern. The World Health Organization has taken its primary healthcare strategy primarily from the international health regulations adopted in 1969. The new version adopted in 2005 coming into force for 196 states in 2007. And then the Declaration of Alma-Ata in 1978, emphasizing a more private sector-oriented perspective, but calling for health protection for all people, regardless of any filter. After the second meeting of the International Health Regulations Emergency Committee regarding the outbreak of a novel coronavirus, a public health emergency was declared by the World Health Organization's Director General on January 30, 2020. On March 11, 2020, the World Health Organization provided a programmatic, non-binding document, Pandemic Guidelines, which set out a set of best practices to manage pandemics at an international and national levels. There is no evidence that the SARS-CoV-2 virus and the COVID-19 illness is transmitted by blood. Rather, the route is primarily through 2 means. 1, their respiratory droplets from the infected person into the air, which are then deposited on nearby surfaces, or secondly, airborne. The virus may be transmitted to other individuals to a distance of less than 2 meters or 6 feet from the infected person or in the general area. The effect of the transmission of the pathogen has been exported to over 150 countries and led to a disruption of travel and related transportation systems, demanded extended conditions, public health services to their extended capabilities, and subjected populations whose personal health conditions were dismissed because of age of certain infirmities, and has impacted confined criminal institutions. But also it should be noted that 70% of all COVID cases has occurred in just 10 countries. Nevertheless, this pandemic demonstrates that it fails to respect national borders and any disparity in national resources or abilities. How states, the primary agent for their domestic public health provisions, handle this pandemic is different from state to state. The question of liability exists under national law and under international law. States could be considered liable under national state responsibility. To this condition, I point to the International Law Commission that has adopted a set of rules delineating what it considers responsibility of states for internationally wrongful acts. Accordingly, states commit a wrongful act if such is attributed to a particular state under international law, and secondly, constitutes a breach of a state's international obligation. China, for example, the virus's epicenter, issued a cordon sanitaire across Hubei province for 76 days, ending on April 8, 2020. Although by this time, when the measure was implemented, upwards of 5 million individuals left Hubei for the Lunar New Year celebration. China has since, beginning on January 23, 2020, curtailed travel into and from Hubei province. In addition to the United States banning the entry of Chinese citizens, North Korea has banned all Chinese travelers from entry, and Kyrgyzstan has closed its borders with China. Given the expense for which this pandemic has given an imprint, the efforts of the World Trade Organization, while extraordinary, cannot serve as the only source for support. To such an end, international law must have a place and role in whatever the globe's states are willing to allow. It is recognized that the approach each state has taken with international law to the pandemic is separated by geography, national capabilities, and above all, political will. There are a number of intersecting fields that appear to be important: human rights, international trade law, personal travel, the role of the United Nations Security Council, and financial aid support. For a general international legal approach and understanding, we begin with our attention to the impairment of human rights, specifically the International Covenants on Civil and Political Rights, the ICCPR, and the Economic, Social, and Cultural Rights, ICESCR, that can serve as bookends for the relationship of international law and a pandemic. For example, the ICCPR mandates isolation and quarantines as the basic non-pharmaceutical prophylactic that calls for social distancing. High on the list of rights to be protected is, of course, human life, which in this instance can incorporate public health and within this pandemic. While not all human rights are equally protected, civil and political rights are most likely protectable when they come under the umbrella of general human rights treaties. The right to health is a guarantee under the ICESCR, which also includes governmental control over the spread of communicable diseases by means of restricted measures necessary for public safety. In order to comply with this requirement, it is necessary for states to provide health facilities, goods, and services, all of which are the foundation of the preventative control and treatment of endemic occupational diseases, and such. In non-emergency situations, human rights legislation requires a specific risk assessment applied to individuals before mandatory isolation or quarantine measures can be ordered. When the threat is community-wide, individual assessments can be set aside for the benefit of the wider population. In such cases, public authorities can impose wide-ranging restrictions on movement. In support of granting authority to limit traditional freedoms during an announced pandemic, support can be found in the Syracuse Principles on the limitation and derogation provisions in the International Covenant on Civil and Political Rights. In essence, the state can operate for a higher good. The restrictive trade law rules suggested by the World Health Organization may conflict with the regulations set out by the World Trade Organization. The legal regime established by GATT World Trade Organization rules for health-related trade restrictions is governed by the Agreement on Sanitary and Phytosanitary Measures, the SPS Agreement, which provides for action to be taken ranging from tariffs to full tariff bans. Pandemic rules can also affect intellectual property when it comes to international trade law. The current attention paid to vaccines and their relationship to unique diseases generally results in the demand for patent protection, often leading to a monopoly over exclusive manufacturing rights of a pharmaceutical product. In this case, the World Trade Organization relies on the multilateral agreement on trade-related aspects of intellectual property. Given the existence of a pandemic, access to stabilizing medicines and intellectual property led to the adoption in 2001 of the Declaration on the Trade-Related Aspects of Intellectual Property Rights Agreement and Public Health, the Doha Declaration. This approach allows for manufacturing licenses to be granted to producers other than patent holder in cases of national emergencies. Individual travel across national borders is a subject for both the departing state and the incoming state. While states under non-emergency circumstances may impose strict limits on entry under conditions of widespread disease, in this case, coronavirus, preventative measures would be normally acceptable, or at least requiring a medical exam, a vaccination, or other prophylaxis. Many states have become aware that the current pandemic has a potential impact on a nation's security. The threat of terrorism that has arisen in the recent past has now included a heightened fear from the potential for bioterrorism. Beyond the efforts of individual states' counterterrorism organizations, on the international level, the United Nations Security Council is in a position to deal with such matters. In the past, when there was a case of disease outbreaks, such as the HIV/AIDS crisis in Africa, the Ebola outbreak in West Africa, the Security Council passed Resolution 2177 in 2014, which called for a massive medical resource and assistance effort to be deployed to the affected areas. Further, the Security Council announced Ebola to be a threat to the international peace and security and established the United Nations mission for Ebola response. More recently, the Security Council passed Resolution 2463 in 2019, dealing with the Ebola outbreak in the Democratic Republic of the Congo. The entire issue of the spread of infectious diseases and their effects on international security appears to be contextualized and dependent upon potential instincts of the Security Council's membership. While we are concerned with the public health and welfare of individuals, the remedies for containment, threat removal, and cures ultimately boils down to funding. It is known and well documented that capital wealth is maldistributed across the globe, which in turn brings an understanding of the priority of those who can expect treatment. Once the current pandemic was upon us, international financial institutions stood up, and in 2017, a steering committee within the World Bank, including the International Bank for Reconstruction and Development and its International Development Association, created what was referred to as the Pandemic Emergency Facility. This group's mandate is an ideal one, providing financial support in cases of disease outbreaks before them that may emerge into pandemics. On the whole, however, these efforts have had little recognizable effort. Now is the time for international lawyers to focus on the core and real issues of the day. The primary concern must be state responsibility and its response to the causes of the pandemic. A question that thus arises is whether or not states can rely on the law found in defense of state responsibility when those states fail to yield to required international legal obligations. There is also the question that must be brought into the equation is whether the procedural requirements for derogation to international human rights treaties is in place. International lawyers often find themselves in position of advisors, providing practical solutions after the occurrence of events or crises. In the case of the current crisis, there must be a time-conscious analytic and ethical cost, calling instead for a thrust toward an expanded, innovative, and creative approach. It is indeed in times like these that general refusals to apply law of science take on supremacy with the support of international law. International lawyers indeed have a privileged access interest to global governance, which permits the opportunity for a restructuring of the legal architecture dealing with any future pandemics. Courts, though often resilient to the demands of their surrounding societies, must, with support from related legislatures, adjust their roles, perhaps taking their lead from the progressive thought of international lawyers. It is sadly the case that global health law has been unable to deter the threat presented by the COVID-19 pandemic. From this condition, a conclusion can be drawn that international law must proceed to clarify state obligations towards public health and ensure a sense of accountability for any failures to provide facilitation of the security and proper medical care that can be normally expected under conditions of a pandemic. Movement in this direction would most likely include such measures of surveillance and reporting, not only of cases of public health data, but also a tiered level of public health emergency outbreaks. To support any such effort, there must be a reevaluation of funding mechanisms that can allow for a globally sustainable national health system able to detect and prevent widespread disease, thus allowing for rapid and targeted response. The most prominent agent operating at the international level is the World Health Organization. It may be necessary to review and enhance the World Health Organization's regulatory authority over individual states' public health laws. Here is a role then for international lawyers, under some administrative structure, to develop and legislate in some forum, perhaps in the United Nations Security Council, a convention dealing with infectious diseases, and one that would include compliance mechanisms. International global order is formed at best when a consensus emerges as a positive response to threats to humanity. To support this conditions is the United Nations, created for this expressed notion. Now is not the time to dither with responses, but to engage and act decisively, employing the tools and supporting values of international law to provide the necessary protection of global health. If I may, I will close with the prescient words of Myanmar's Aung San Suu Kyi, who told the International Court of Justice, international law may well be our only global value system. I hope I've not stepped on the analysis toes of presenters following me. If so, I apologize. Shukran.
Prof, thank you very much for your presentation, and we appreciate your sharing to our conference, and inshallah in the future we are looking for other academic collaboration, inshallah. In brief, I'll conclude your presentation in only 2 minutes for my colleagues. Prof سيلفربيرغ يتحدث بشكل عام عن الآثار الدولية لكوفيد 19 وتطرق للعديد من المحاور، منها المحور اللي له علاقة بحقوق الإنسان، والمحور اللي له علاقة بالتجارة الدولية ومنظمة التجارة العالمية، وشو هي الجهود الدولية اللي بذلت في سبيل احتواء الأزمة. وكان بيحكي إن أيا كانت يعني آثار الأزمة سواء كانت اقتصادية أو سياسية أو اجتماعية، فإن الحلول يجب أن تكون قانونية. اتطرق لبعض الجهود الدولية فيما يتعلق بالتعامل مع الأزمة، مثل مقررات مؤتمر باريس اللي كانت أهم توصياتها أن لازم يكون في توحيد للإجراءات والتشريعات الخاصة بدول الاتحاد الأوروبي للتعامل مع الأزمة. اتطرق لبعض الهيئات الخاصة اللي أنشئت في منظمة الصحة العالمية للتعامل معها، واتطرق كذلك إلى قرار صادر، هو استعمل مصطلح ICC، أعتقد هذا أبريفيشن أو مختصر لغرفة تجارة باريس، إن شاء الله أكون صادق فيما يتعلق بالتجارة الدولية. كان في بعض التوصيات خاصة نركز في الجانب النهائي والأخير على الأمور المتعلقة بحقوق الإنسان، وكانت توصياته النهائية أن الأمر جدا يختلف عن أزمة سارس أو أزمة فيروس سارس اللي نشأت في 2013 أعتقد في الصين واليونان، أو 2015 مش متأكد من السنة اللي حكاها. أن يجب أن يكون في تشريعات دولية للتعامل مع الأزمة، يجب أن تكون أو توجد مظلة دولية لحماية حقوق الإنسان في الظروف غير العادية اللي بنعيشها، ويجب أن يكون في تمويل دولي. التمويل الدولي الغرض منه التعامل مع أزمات مالية مستقبلية. اتطرق أيضا إلى موضوع جدا مهم، إذا كان الفيروس مخلق واستعمل مصطلح أنه ممثل represented in China، يبقى هنا قد تنشأ المسؤولية المدنية للدول المسؤولة عن تخليق أو إيجاد الفيروس. ولكن هو في البداية يعني بكل أمانة أشار أن حتى الآن لا توجد تأكيدات أو لا توجد مؤشرات علمية تؤكد أن الفيروس كان مخلق. Thank you very much again. الآن وفقا يعني أنا آسف إني بحكي على عجل لأن شوية الجلسة الافتتاحية أخذت معنا وقت أكثر مما معد له. الآن بعرف سعادة المدير حضرتك معنا، إذا تأذن لنا بإنهاء الجلسة الافتتاحية سعادة المدير.
نعم أنا معاكم دكتور، تفضل.
حياك الله، احنا دائما تعبينك معنا يا سعادة المدير، يتحملنا. بارك الله.
لا أبدا، أنا معاكم وسامعكم
إن شاء الله. حضرتك يعني والجميع المستمعين فيما يتعلق ببرنامج المؤتمر، احنا في عندنا 4 جلسات إن شاء الله. في الجلسة الأولى والثانية هتكون بالتوازي وتحكي على أثر الجائحة فيما يتعلق بالقانون الخاص، والثاني عن القانون العام، وهتبدأ إن شاء الله 9:30 يعني بعد 20 دقيقة من الآن. يعني الحمد لله في معنا وقت بريك للأساتذة يرتاحوا شوي. بعد هيك في عندنا بريك لمدة نص ساعة. هيكون في عندنا الجلسة الثالثة والرابعة أيضا بالتزامن، وهتبدأ الساعة 12 وهتنتهي الساعة 2 إن شاء الله. سعادة المدير يعني وفقا لما هو مقرر في الجدول الملتقى، في عندنا راحة الآن. أرجو من حضرتك لو تتفضل لنا بإنهاء الجلسة، أو إذا كان عند حضرتك في تعقيب يعني إحنا شاكرين.
شكرا جزيلا دكتور محمود. بالواقع أنا عجبتني كلمة سعادة العميد وكلمة الأستاذ الضيف، فبالنتيجة أنا أطلب منكم، ولو أعتقد هذه ما تفوتكم، أنه تعرف هذا الموضوع من الموضوعات المهمة جدا، خاصة في الأمور القانونية لهذه الكورونا التعيسة الخبيثة. فأتمنى لو يصدر قرار توصيات وبعض المعلومات المهمة اللي يحتاجها المجتمع باسم المؤتمر وباسم كلية القانون إن شاء الله. وأنا سأبقى معكم إن شاء الله، وتفضلوا على برنامجكم. شكرا.
إن شاء الله. بارك الله فيك وشكرا لجهودك جزيلا. ختاما في الجلسة يجب علينا أن نشكر زملائنا وزميلاتنا في الهيئة الإدارية في الكلية، وأيضا نتوجه بجزيل الشكر لأعضاء اللجنة التنظيمية للمؤتمر، الدكتورة آلاء النعيمة رئيسة اللجنة، وزميلنا الفاضل الدكتور علي تركي والدكتور شادي جدفات أعضاء اللجنة. أعتذر عن الإطالة وبارك الله فيكم حسن استماعكم. والآن سعادة العميد لو تسمح لنا بعد إذن المدير إن احنا 20 دقيقة راحة للزملاء علشان فيما بعد إن شاء الله نستكمل جلسات الملتقى. بارك الله فيكم وشكرا جزيلا على حسن الاستماع.
شكرا جزيلا. شكرا لسعادة المدير، شكرا للدكتور محمود. نحن فقط بدي نوه انه روابط الجلسات الموازية مختلف عن رابط الجلسة الافتتاحية وفق البرنامج المعد. شكرا جزيلا.
شكرا جزيلا. بارك الله فيكم. الآن استراحة إن شاء الله 15 دقيقة ونرجع بعدها للجلسة الأولى والثانية بالتزامن. بارك الله فيكم جميعا وشكرا جزيلا.